So music copyright is back in the news again as the Ed Townsend and Ed Sheeran court case goes to court over a chord progression. Really? Is that? Look, there's a lot to unpack about this court case and what it means for the future of the music industry. And it really highlights some of the problems with the copyright law today and how it's understood in the court systems and the impacts it will have on musicians and songwriters. It isn't as straightforward as, oh, there's a chord progression. There's a lot more to it. Now, I'm gonna say straight off the bat, personally, I think that Ed Sheeran should win this case. But I think there is a strong chance that he might not. So let's chat about copyright and music making and find out why I think that. Hey, my name is Steve and welcome back to Command Shift New and this episode of Ask Your Lecturer. Whenever I bring up copyright in the classroom, it pretty much causes a riot. Well, maybe not a riot, but it certainly is some of the most engaging and debate-based discussions we can have in the classroom. Copyright is the protection of intellectual property, and that can apply to audio recordings or it can apply to the composition of the song itself, the actual song that's been written and all of its elements. In the case of copyright over audio recordings, that sort of covers things like sampling within the music industry, as well as even music piracy and the distribution of music illegally. In the case of copyright over composition, we're talking about ideas or melodies or themes and things that have been written by someone else and then copied exactly. We're analyzing things like melody, structure, harmony, and rhythm. Basically talking about plagiarism. And let me tell you, in both of those cases, you get some pretty polarizing comments and opinions on either side. So let's take a look first of all, why am I talking about this? So Ed Sheeran is one of the writers behind Thinking Out Loud, and he's being sued. And he's being sued by the estate or family of Ed Townsend since he passed away, who was a writer on Let's Get It On, one of Marvin Gaye's hit tracks. And he's being sued based on some similarities. What are these similarities? Well, basically just the chord progression in the verse of both of those tracks have a similar chord progression. But Ed Townsend's estate basically argued that that chord progression in combination with the similar rhythmic accents and the arrangement of the track in that section constitutes a unique copyrightable sound or idea. It's true, the chord structures are similar. 4 chords are used, and while the second chord in both chord progressions is slightly different, they do follow a similar sort of function. And that's because of something called functional harmony. Functional harmony kind of groups chords within a certain key into 3 main functions, either the tonic, the predominant, or the dominant. The tonic sort of feels like home, it's, you know, the sort of root of the key. The predominant feels like a departure from this, like you're leaving home, heading towards a new destination. And the dominant feels like the peak of the journey, that sort of final destination before it turns back around and points towards home again. So these 3 sections kind of point to one another, tonic to predominant to dominant, back to tonic again. Now, I'm not going to play you any examples from these 2 songs because frankly, I don't want a YouTube copyright strike. Ironic! But if you want a deep dive and a comparison between the 2, check out Adam Neely's videos as well as Rick Beato's videos on this particular topic, this exact court case. Both are very insightful and, kind of interestingly, arrive at slightly different conclusions. I'd let you check that out after this video. But if both tracks share an almost identical chord progression, isn't it sort of an open and shut case, you might be asking? Well, I don't think so, and many musicians would probably agree. So you see, in my assessment and the assessment of other musicians as well, the thing that Ed Townsend's estate is trying to sort of protect and defend is actually a stylistic element or a combination of these musical building blocks that are core to a specific genre. Basically, it's like trying to claim that you were the one that came up with bricks for a house build, so you can't let anybody else have any bricks. No one else can build with anything that closely resembles a brick. In most copyright cases, they're usually looking at the melody, but in this case, they are definitely not looking at the melody. They're looking at the backing track, what's behind the melody. Why do courts normally look at the melody? Well, because there are only so many chords you can actually place underneath a melody, and only so many ways to rhythmically emphasize those. For example, in every major scale, there are 7 chords that you could use that are diatonic chords to that key. So if you were to use these chords over 4 bars for 4 chords in your song, you could only have a grand total of 2,401 different chord progressions. Or basically 7 times 7 times 7 times 7, because there's 7 possibilities for the first chord, 7 for the next one, and so on, you get it. Mind you, that list of possible chord progressions includes 7 different chord progressions where it stays on the same chord for every one of those. Yay, drone music! And herein lies the problem. Not all of those chord progressions are going to be ones that you want to use, or frankly, ones that actually sound good. Chords follow harmonic conventions, and genres tend to gravitate towards specific conventions. For instance, pop music generally follows functional harmony pretty closely. It flows from tonic into predominant into dominant fairly easily and quite often. And that is literally the harmonic function for both of those tracks. They both follow that, albeit a couple of little changes in the second chord there. So surprise, surprise, they sound both like a pop song and fairly similar at that. The thing is, in a major scale, there are sort of three main chords that can have a tonic function. The first, the third, and the sixth. And that's because the third and the sixth share two notes each with the main tonic. So they sound similar and they share a similar function. Two chords can belong to the predominant, both the second and the fourth, and two chords can belong to the dominant, which is the fifth and the seventh, because of shared notes again. So in reality, if you want to be a pop song following that functional harmony of tonic to predominant to dominant, you really only have a few chord options. You don't have 2401, you have 36. That's 3 times possible for the first one, 3 times for the next one, and 2 for the last 2 chords. 3 times 3 times 2 times 2 is 36. And are there more than 36 songs released globally across the whole of time? Spoiler alert, if you haven't already realized, yes, there most definitely are. So the question is, can you really own a musical genre's concepts and conventions and functional harmony itself? Sure, someone had to come up with that chord progression first, but I can guarantee you it is not Ed Townsend. There are so many songs that use that chord progression. It's very famous. So famous, in fact, that there's this Australian comedy group, Axis of Awesome. They get up on stage, they play the same 4 chords over and over again and sing like 30 or 50 different tracks over the top that all share the same chord progression. They actually showed this video in court as part of Ed Sheeran's defense, which I find absolutely hilarious because I share it in my class for exactly that reason, to show and demonstrate just how common that chord progression is. Hilarious. At the end of the day, a genre's songs only sound similar because they're all using the same sort of building blocks to start that song and build the song up from. You can't tell an artist to stop using that building block because someone else used it first, just like you can't tell everyone to pull down their brick houses because you thought of it first. Ultimately, the problem with copyright law is it hinges on this idea of proving if someone deliberately copied an idea or if they just came up with it independently on their own. And good luck proving either of those without a shadow of a doubt. So that's why they look at the building blocks a lot of the time, because that's evidence as to whether these things are actually the same. The issue is that most of these building blocks, these individual elements of songs, are part of a codified system within a specific genre that everybody uses, that they use to build together and create their track. Nearly everybody writes within a particular genre, so if they do that, they're going to share similar rhythms, similar chord progressions, even similar melodic contours, because they exist all in the one space. It's possibly easier to understand recorded audio copyright, as there's sort of this physical recording that is sort of stolen or used without permission. But no, even this is a little bit grey. Yes, the physical recording of, say, a Beatles track, you can't just grab that and claim it as your own and say, it's mine and I use it and I own it. But if you sampled a piece of it and then you manipulated it quite a bit and put it into your own track and use that small piece in a much larger track of your own, is that copyright? Strictly speaking, yes. And in a lot of countries, including Australia where I'm based, you absolutely cannot take someone else's audio without their permission and use it in your own track. That's the sort of letter of the law. But hip hop has a proud history of wonderful creations that have been sampled, sampling breakbeats or other parts of the song and mashing it and recontextualizing it and morphing it into something unrecognizable that is distinctly that person's work of art. So in cases like these, the court often look at the stolen audio and see if it's 1, recognizable, and 2, whether it constitutes a prominent use or a significant portion of that track, i.e., has this artist taken something that someone else's, stuck it into their artwork, and relied heavily on it to make their song good? If not, if it's just a throwaway piece or it's a small line or you can't even recognize it, then most of the time it's a little bit more up for debate. I can't really say one way or another. Obviously, it's worth mentioning at this time, I'm not a music lawyer, I'm a music creator. But just going purely on court precedents, that's sort of the way that they usually look at those things. But this is why Ed Sheeran could end up losing the case, and why I would think it would be devastating for the music industry if that was the case. Copyright law isn't being debated amongst musicians. It's being debated by non-musicians, lawyers, estate holders, family and beneficiaries, business interests. And these people don't look at music with the full understanding of a musician or artist or creative person in general. And this really goes for all forms of art in a way. All music in some form or another is derivative from someone else's work. because we simply don't create in a vacuum. The originality, though, comes from the way that we take these influences and uniquely combine them into our own voice, into something brand new and its own artwork. It's the classic, we're standing on the shoulders of giants. People who've come before us have paved the way and given us tools to use, and those tools we can use to create new works of art. If a non-musician or even a musician decrees that they have ownership over a genre's style or artistic building block, they will be claiming ownership over the building blocks of songwriting itself and becoming a miraculous co-writer on every song that came after it. Copyright law is meant to protect people against the theft of their intellectual property and the plagiarism of their work. But I often feel it's misunderstood by people who view music like a product, like some kind of new technology item or something, instead of looking at it like a piece of art that takes influence from lots of different places. And incidentally, quick side note, I think it's great when artists share who those influences are so we can actually see the credit where the credit's due and who influenced them. Instead though, other people might view music as the sum of its parts, and each one of those parts is copyrightable by its own right. That's what's happening in this case. They're trying to copyright that particular element within music to say that it's their own thing. In treating music in this way, you kind of hamstring all creatives and musicians in general, preventing them from thriving at what they're doing. It disrupts the very way that we create music and the way that we train musicians on how to create music. In fact, we teach people how to take influence from other people and develop their own work based off it. With practically all music being derived from the work of others, you would reduce the music from the outpouring that it is right now with so much work coming out to a mere trickle of what it is, for fear of being copyrighted against. The thing is, it would actually destroy the music industry that gave the fame and recognition to the original artists in the first place. Ironic! Because that product will no longer be allowed to be made by other artists and kind of stop the machine dead. Music, I think, should be thought of more like a conversation. People may use the same words as you, or even the same phrases and combinations of words as you, but their unique vocabulary and their life experiences will shape their speech differently. The people who have influenced them and spoken to them throughout their lives is going to change the way that they structure their words. Sure, if someone copies you word for word, you're allowed to be upset and seek protection against that. But I don't think you can get mad at someone who uses some similar words to you occasionally, or has a similar structure or flow to you but uses their own flair and imagination on it. It's just how we talk, it's how we've agreed to communicate, and they're just following along with that. Otherwise, journalists would be plagiarists every day as soon as they write up the news of the day because of the way of them following a similar structure. Authors would be plagiarists as well for following the similar story arcs or the same character profiles. Motivational speakers would also be plagiarists for using the same pausing feature in their speeches. Food for thought. So, do I think that my opinion is going to matter to the courts? No. However, I think that copyright law is sort of mismatched to the everyday artist and the experience of the artist and musician. It creates confusion and fear where it should be protection and it should be comfort. It turns genres and the music that makes up those genres into potential ownership battlegrounds. And it creates haves and have-nots based on how much they can afford to spend on legal costs. Who can actually afford to go into battle? If you want music to grow and to thrive, free access to common building blocks like chord patterns and structures are going to be really important. Otherwise, just get used to the sound of crickets. Anyway, that's my 2 cents and video rant, I suppose, on this issue. I hope you got something out of it all the same. If you did, why not consider subscribing, because you get to stay up to date on things that I'm thinking, or you can hit like below to let me know that you enjoyed the video and to support other musicians as well. So subscribe on your way out, but otherwise I will catch you in the next one.